So does this mean people can hear me?
Yep.
Okay, and we can start to see participate. Oh, you're 34. There we go. 43. Wow, 58. They're all happening. It's all coming. That's good. That was a good sign up.
Definitely.
So when do you want to go?
It's up to you. There's a few people on questions saying hello to you, Sue.
Oh, is there? Okay. Open questions. Oh, no open questions.
Yeah, oh, in the chat.
Oh, chat. Sorry. Getting used to all this stuff. More questions. There we go, chat. Hello, David Skegg, Carolyn, Joe, Max, Rachel Lopez, Mark, Rob, Bruce, Nichols. Lovely. Can you hear me? I can't. We don't need to hear you, Tony. As long as everyone can hear me. All right. Okay. Do we want to get going?
If you're ready, you can start going.
I'm ready. Okay. I'm just clicking on questions. Hi from Charles Darwin Uni at Darwin. Wonderful. Okay. All right. So we're just going to get underway. Thanks for everybody joining in. I hope you're all... oh, now I've done it straight away. Here we go. I hope that everybody's enjoying this time at home, getting things done. I know it's all very unusual times, but the one thing we're not going to talk about today is COVID-19. So just to introduce myself again, I'm assuming most people know who I am. That's why they've signed up for the webinar. Sue Bottrell. I'm a OH&S professional, member of the Australian Institute of Health and Safety. Thank you very much to the Institute for hosting the webinar. And I'm also a lawyer specialising in OH&S and specifically in contractor management. I started working in the area of essentially occupational health and safety, liability and management for contractor safety a decade ago. And what got me going on that really was the realisation that there was a very poor understanding of what the obligations are around how to manage contractor safety. I originally started looking at it through the legal lens as a result of the Baiada v. the Queen decision, which we'll talk about in a minute. But also that's led me to put my safety professional hat on and say, how do we manage contractor safety effectively? And you know, I've come up with a four-pillar process or a four-element process, which I think really highlights the sort of things that we need to be doing to achieve the sort of outcomes that we want from contractor management, rather than just having, you know, complex administrative systems with lots of paperwork and so forth, but really putting our efforts where we most want them to be.
Well, you can do this, so it's Sarah.
Yeah.
Can you just share your screen again? We can't see your presentation.
Oh, hang on. Stop share. No. Is that share screen?
Share your screen. We can't see your presentation there. There we go.
Rightio, from the beginning.
Yeah.
Okay, you back?
Yes.
Okay, great. So if people have questions, please just post the questions in the question little section, and Sarah will read those out to me as we go along, because I find it a bit hard to jump from the question screen to the actual presentation screen. But I do like people to ask questions as we go along, and we'll just manage those as best we can, and we'll give responses as we go. Okay, so let's get underway. So obviously every time, whenever you go to safety training, someone says, why should we manage safety? And really the question is, why do you want to manage contractor safety? Obviously, there's pretty standard responses around prevention of incidents, cost of incidents, and all of those things that go with it. And really, when you think about it, it's split into two things. One is to manage liability, legal liability, and the costs that arise out of having an incident in your workplace under health and safety, breaches of health and safety legislation. And on the other side is the more, I suppose, ethical, moral obligations around preventing incidents. Nobody wants an injured person or a dead person at their workplace. So there are, you know, real motivations. But I think what's really important is we need to be clear what we're trying to achieve with each stage in contractor management. And we need to understand that there is the harsh, cold world of legal liability, and then the more esoteric world of safety prevention. And you need to get your head around, we behave differently in each one of those spaces. And so by going through these four elements, you can think about, what am I trying to achieve in this process and this part of the contractor management process, and focus your efforts accordingly. So, you know, by the end of this, hopefully you'll be able to say, okay, this is what I'm trying to do, and these are the things that I need to be, the activities I need to be undertaking. So the process really sets out an end-to-end process of how to effectively manage your contractors from a safety management point of view, to both protect you, your company, from legal liability, but also to achieve improved outcomes in terms of overall safety. So as I said, when I started working in this, I actually got involved in this as a junior lawyer. I had a client who was prosecuted by WorkSafe. They were a builder, had engaged an independent contractor to undertake the removal of a roof. That independent contractor was working entirely independently. They were a specialist contractor. The builder had no control over how that work was being done. Essentially, the site was handed over to the roof removalist to run the show from start to finish. A fellow fell down a light well, was very severely injured, and WorkSafe prosecuted the builder as the principal contractor for failings on the part of the contractor. And at the time, I just went, that doesn't make a lot of sense to me. You know, how can you be held responsible for something you've got very, very limited control, knowledge, all that kind of stuff? Anyway, the partner I was working for at the time said, no, we probably need to plead guilty because WorkSafe always win. So they did, and of course were fined $15,000. But following, and that was in 2011, following that case, there was the decision in 2012 of Baiada v. the Queen, a High Court decision that basically turned that whole presumption on its head. Now, I want people to note that it wasn't, this decision in 2012 was not the start of the change of how we need to think about contract liability for contractor safety. There was a case in 1895 which actually articulated these principles, but for some reason we'd spent over 100 years essentially ignoring the case law. And a myth had grown up, a very powerful myth, that resulted in people unfortunately focusing their efforts in entirely the wrong direction when it came to managing their contractors. And essentially what the High Court said in Baiada, I'll run through quickly what happened in Baiada. Baiada is a poultry manufacturer. They engaged 3 contractors, a farm, chicken catchers, and a transport operator to collect chickens and take them to their factory for processing. The farm grew them, obviously. The chicken catcher was on site to catch them, put them into modules, and then load them onto the truck for the transport operator to take them away. While the process was happening on the farm, one of the modules was being loaded onto the truck, knocked another module which fell off and hit the truck driver, Mr. Azzopardi, and killed him. And WorkSafe prosecuted Baiada for failing to ensure that those contractors had safe systems of work in place. WorkSafe won at first instance. They won on appeal, and it went all the way to the High Court, and the High Court basically just looked at it correctly through the lens of reasonable practicability. is it reasonably practicable for a contractor, for a principal contractor, to direct and control the operations of an independent contractor? And they made the decision that no, it is not, and it's for these reasons. So the expert nature of a contractor's work, and possible, I've put possible there because I'm going to talk about lack of knowledge on the part of a principal contractor about the risks associated with that work, the cost and effort of directing an independent contractor. And I just want you to reflect for a minute on the billions of dollars that have been spent over the years on principal contractors running around, reviewing, approving, supervising and directing independent contractors in how they do their work, and the questionable benefit of doing that. And the nature of a contract between a principal and its contractor, which is one of independence. The independent contractor is coming to you to deliver a service. That is their job. That's what they do for their business. They are independent from you. They choose how they're going to do the work, probably when they're going to do the work, all of that stuff. You are meeting your contractors on equal ground. You've got an independent contractor and the principal contractor. They are both employers for the purposes of health and safety, and you are meeting on equal ground to decide what work that independent contractor is going to do for you. And all of these factors make it not reasonably practicable, which everyone would know is the test, which determines the risk control, whether or not a risk control has been effective, or whether you've met your obligations under the legislation. It is not reasonably practicable for a principal contractor to direct an independent contractor in its safety arrangements. They were really clear about this, and people talk about, oh, it's a non-delegable duty, you can't contract out, all of those things. The reality is that what they did was look at, is it reasonably practicable for a principal contractor to direct an independent contractor? I'll go back to that possible lack of knowledge, because they went on to say, of course, where you don't know what sort of work an independent contractor is doing, it is not reasonably practicable for you to direct them because you just don't have the knowledge. But they went on further and said, look, even where you do have the knowledge, it's just not practicable because of the type of relationship with your contractor for you to start telling them how to do their job. It is one of separation. I'm just going to move my camera a little bit. One of separation. I see some questions piling up there, Sarah. Have we got any?
I was going to say a few questions there. Susan's asked, I've asked where our pandemic plan is. The silence has been deafening from the workplace. I'm an OHS representative and a university. Your thoughts?
Look, Susan, this is not a webinar about COVID and pandemic planning, so unfortunately I can't help you with that question today. But I just, I'd go back to your senior OH&S people and say, where is it? But yeah, unfortunately it's not a question for today. I can actually see the questions, Sarah. Do you want me to run through them?
Yeah, perfect.
David Skegg, labour hire companies are in a different position to the Baiada decision. Where will liability lay where a labour hire company has their own OH&S rules, as does the client company, who sometimes demands adherence to theirs, as well as auditing the labour hire rules? Labour hire is an interesting question, and it's one that I've turned my mind to quite a bit, and I think is actually very open to some further considerations. I think the important thing to think about, the way to think about labour hire is a body coming to a host's employer. The host has entire control pretty much over how that person is going to do their work. So the lion's share of obligation will rest with the host employer. And labour hire companies have an obligation to ensure that they're placing their people into a safe workplace. And I suspect some of the issues in Baiada, such as, what knowledge do you have about the host workplace, how suitable is it for you to be, or can you direct what goes on in the host workplace, will come into play here. But it is a really important thing, and I just say to people who are using labour hire, treat them as your own employee, as a host, if you are a host employer, because you've got all the control. we've got, Mark Wagner says, what is the 1895 case? Sorry, Mark, I knew someone would ask that. I can't recall the name, so I will actually have to look that up and come back to you. And Andrew Noakes just says here about COR, chain of responsibility and workplace health and safety. The very good news about this is that the principles I am talking to you about in general contractor management are now exactly the same principles as applied under the heavy vehicle national law. So Baiada v. the Queen is the High Court decision that the COR, chain of responsibility changes enacted under the heavy vehicle national law in October 2018 are the principles that inform that legislation. So you can take the presentation today and say, and this applies to the application of chain of responsibility obligations under 26C of the HVNL. Okay, all right, so I'll keep going and I will come back to some other questions as well. Let me just drop that down there. We're still okay, Sarah, with slides and whatnot?
Yeah, all still looks perfect.
Okay, so essentially what that did was establish the principle that your contractors are separate and independent to you, and you are entitled to view them that way. So I'll just, what's my thing doing here? Oh, there we go. So these are some of the legal principles. The principles set down in the Baiada case have been adopted in every jurisdiction across every level of courts in every state of Australia. And I actually did a post today on LinkedIn, so jump on and join me on LinkedIn, about a decision that came out of the New South Wales District Court, which I think is somewhat unfortunate because it did not reflect the precedent set down in Baiada, didn't even refer to the case, and I think is very problematic. So go and have a bit of a look on LinkedIn because there's a post there today. But these are some of the principles that have come out of case law since, which back up what the High Court was talking about. Common law does not impose a duty of care on principal contractors for independent contractors engaged by them of the same kind which they owe their employees. So you need to think about it differently and go, yes, principal contractors have duties to contractors, but they are not the same as to your own employees. Why? Because you do not have the same level of control. So the key concept that the High Court talked about was a principal contractor will owe obligations to a contractor over matters over which it has control. You don't have control over the way an independent contractor is actually doing their work. And I'm not talking contractual control. I'm talking actual control. You're not going, and one of the High Court judges said it would be ludicrous to have a plumber and an electrician turn up to my house and have me start to direct them in how they're going to do their work. There's no obligation for a principal contractor to train subcontractors in how they do their work. So there is no requirement to issue safe work method statements and tell a contractor how to go about doing their work safely. We'll talk about SWIMs soon. I'll just try and keep an eye on the time. This is an important one. Principal contractors are entitled to rely upon the expertise of competent and experienced contractors. You can reasonably rely upon your contractors. A great point they made was the use of expert contractors is a practicable method by which a PC may discharge its OH&S obligations. So I have a business, I want to undertake some work. That work is outside my knowledge and my expertise in my core business. So to make sure it's done safely, I bring in the experts. So why would I then turn around and start to tell those experts how to do their job or try and monitor what they're doing, all that kind of stuff? It is not reasonably practicable to implement, review or monitor the work methods of independent contractors. So it is very clear about what it is that, the limitations on what a principal contractor owes towards their contractors. And really, if you think about it, this is not just legal, it just makes sense. When you think, yeah, okay, I've got somebody here who's undertaking some specialised work because I don't know how to do it, or even if I do, they're there doing their work, why would I be stepping in and starting to control them? So these are some court cases that have come down, high court cases, Supreme Court cases. And basically it says once you hand over a job and it's in the hands of the independent contractor, they are responsible for managing the risks arising from that work. I'll just go back to the question page.
Sarah, did you want to have a quick look at some questions?
Yeah. It's just got who's responsible for contractors engaged in domestic work. Well, the reality is that residences are not caught by OHS legislation or workplace health and safety legislation anyway. So residents or owners, even owners corporations, which is a whole other topic, are not legally responsible under their legislation because they're not employers or they're not PCBUs. Let me just have a look here. What would be an example of a non-independent contractor? I don't really know what that means. You know, it's you're essentially an independent contractor or you're an employee. That's kind of how it works. Requirement to consult under Section 46 should mean PC has a good idea about the safety issues of an independent contractor. The requirement to consult is for the PC to ensure that the contractor, they talk to their contractors about the safety issues posed by the principal contractor, any safety requirements that that principal contractor has in place to manage those risks, and are communicating and consulting with the contractor about what they're doing that can impact on the contractor. It's actually not about going to the contractor and saying, tell me everything about what you're doing. You know, admittedly, you know, if you've got a site and you want to have a bit of an idea that the contractor knows what they're doing so they're not causing risks on your site. So say they're coming to a major hazard facility and you need to know they're not undertaking hot works or something like that. What about this? Partnering agreements, PC or main contractor moves into a partnering type agreement. No, so really this is about where you've got an independent contractor, they've gone to a contractor themselves and the relationship is one of independence. Are all contractors considered independent? Well, look at the relationship and just say, look, is this person operating independently to me? All of that kind of stuff. Do you think the regulators across Australia understand this concept? They're all getting a whole lot better. But yes, it's a journey and I continue to have that journey and I have regular involvement with the regulators around these. Well, I appreciate the position you articulate is supported by, but what is the purpose of the general duty of employers? So the general duty of employers sets down that you have obligations, okay, as an employer. Those obligations are then modified by the application of reasonable practicability. So reasonable practicability is informed by the important elements of knowledge, suitability and cost and effort. And they were the ones that the court considered in relation to contractors and in relation to matters over which you have control. So yes, there's a general duty. Yes, there are duties owed to contractors, but the way that those duties are executed is quite different as between our own employees and the contractors. Sarah, can you hear me? Sarah?
Yeah, I can hear you perfect.
Just my screen disappeared, sorry.
Oh, okay.
All right, so I'm going to keep going on. So the Waco Quick Form, here's an interesting case. Waco Quick Form is a scaffolding company. They engaged a subcontractor who's a scaffolding company. They didn't like the way the scaffolding company was doing their work. So they actually prescribed a safe system of work for scaffolding company to follow, the subcontractor to follow. There was an incident. So who do you think got held, who was liable? Quick Form. And the court observed that up until the point at which Waco issued the safe work method statement or the safe method of work, they did not have an obligation for the way that the independent contractor was undertaking their work. As soon as they issued those instructions, they did. So be very careful that if you go down the path of saying, oh, but I think I really need to be telling my contractor how to do their work, you have just assumed a whole ton of liability. And you need to make sure that you're issuing those instructions with proper training, proper monitoring, proper supervision, proper resourcing in how to comply with them. So you've just created a massive obligation for yourself, and you go, why did you even bother employing an independent contractor if that's what you're going to do? So, you know, there is no doubt that there is a real separation. But what should we manage? I'm not saying there's no obligation from a principal contractor to a contractor. What should we manage, and where should we be focusing our efforts? And we need to be focusing our efforts on matters over which we as the principal contractor has control. So that is our own undertaking, our business and the risks that our business creates. Our site. So if we have contractors attending our site, we better make sure we don't run over them with our forklift. We need to do inductions. We need emergency management, all of those things. The problem with contractor management in the past is we've all been looking in the wrong direction. We've all been looking over there at our contractor and saying, what are you doing? How are you managing your safety? And what we actually should be looking at is, what am I doing, and what am I doing to make sure I'm keeping my contractors safe? Because that's what you're responsible for. So if we keep going there, so what do we mean by control? As I said, our site and our operations. So think about your business, your site risks and your operational risks, and they are the sorts of things that you need to be considering in relation to contractor safety. I'm going to jump over that one. So we're going to have a little bit of a think about appointment of principal contractors, because in the construction legislation, a principal contractor can, or once the job is over a defined amount, in Victoria it's 350,000 K, a principal contractor must be identified. There must be a principal contractor to essentially coordinate the works and make sure that there is an OH&S coordination plan and all of those sort of things. And by default, the principal contractor of a large construction project is the owner of the project. However, under the regulations, an owner of a project can appoint another party to act as a principal contractor. So the classic example is the school says, we're going to build a new entertainment hall at the school. It's going to cost us $1 million. We don't know anything about building buildings, so we're going to appoint Leighton's or Grollo or somebody to come in and build this building for us. And what they do is they're essentially appointing that principal contractor. They are authorising that third party to manage or control the workplace on their behalf in terms of health and safety. And you need to make sure there is a valid appointment and that it's really clear that the job has been handed over to that third party to act as the principal contractor. So a principal contractor's duties are to engage contractors, and there's an element of due diligence around that. Coordinate your contractors, manage your site safety, do incident notification if you're occupying the site emergency response, ensuring safe access and egress, displaying an OH&S coordination plan, those kinds of things. So a principal contractor's role is one of coordination and oversight, and making sure that there is a coordinated approach to managing the project and managing risks that impact on the entire site. Sarah, can I just get you to scan some of those questions and maybe pull out one or two for me? Because I see there's 37 of them lined up.
I was about to say there's quite a few lined up.
Yeah, can you just run through them and perhaps pick out a few that might be more relevant? So the principal contractor, what are you not responsible for? So you're not responsible for approving, supervising the safety arrangements of independent contractors. You're not responsible for directing contractors in how they undertake their work. And in fact, doing so may increase the liability of principal contractors in the event of an incident. It also reduces the time spent on safety by often spending time looking at preparation documents. How many of us have spent hours pouring through piles of documentation saying, from your contractor saying, here's my safety management system and this is how I manage safety. Highly questionable anyway as to evidence of safety management on the ground, and there's been a lot of work done on, you know, the questionable benefit of copious safety management systems in terms of documentation. I quite frankly don't believe pretty much anything that's written down unless I can get some verifiable actual evidence to go with it. So, you know, what we need to do is to go through a process of clarifying who's who in the zoo, who's got what role, and establishing that relationship, and then going through the 4 other elements of contractor management, which I'll get onto. So the role of contractors, they have to control risks arising from their operations. They have to ensure that their work doesn't pose a risk to others. They've got to consult with their principal. They have to notify about incidents. They've got to comply with site safety rules and procedures. So it's up to them to say, what is my work and how do I control those risks and comply with my legal obligations as an employer under the OH&S legislation. Sarah, got any?
Yep. I've got one here from Danielle. To what level would it be a reasonably practical to monitor contractors?
Okay, we're going to get onto monitoring. So we'll talk about that in a minute, Danielle, because I'm now going to talk about, I just want to check what the time is. My phone just turned itself off.
It's 3:30.
Okay, so now what I want to do is actually talk about the 4 phases of contractor management. Now that we're all really clear that there is a very defined separation between us and our contractors, contractors and principal contractors are equal parties, both employers under the legislation who must manage their own safety risks. There are the 4 steps to how do you do that, manage the relationship going forward, because we want to manage our liability, but we also want to improve prevention and improve our safety outcomes. So the 4 elements are a pre-qualification phase, an onboarding phase, a monitoring phase, and an overall performance review. And I'll run through those, and I'm just having a quick scan. There's lots and lots of questions coming in. Yeah. Did you see any others that? Yep.
There's one here from Effie. The construction industry generally has a different relationship with their subcontractors and treats them like employees where some of the work is involved. How do we educate and drive some change?
Well, essentially what we need to do is, you're quite right, the construction industry has historically been all about control, and one of the biggest problems has been a misunderstanding around safe work method statements. And there was a misunderstanding for a very long time, and I've picked up this issue and run with it quite strongly, where there was an expectation that a principal contractor was the one who needed to draft, issue, supervise and monitor safe work method statements. That is actually an incorrect interpretation of the legislation. The obligation rests with the employer who is engaging in the high-risk construction work. Now, I just want to go down here. SWIMs. So, SWIMs are a safety planning tool. They are meant to be, and I can see the legislators when they drafted this, what they intended it for was that you would go, you would look at the task as the people undertaking the task and say, right, what are my risks here and how am I going to control them? At the time the work is being done, taking into account the factors that impact on that work. So yes, we've got a high risk construction task, which is working at heights, but by the way, it's raining today, or we can't get access to the site, or there's traffic coming and going. And I have to think about my risk controls in the context that it's occurring. So they're not required to be developed for all and any work being undertaken. They are only required for high risk construction works as defined under the regs. There are 19 high risk construction tasks. The purpose of the SWIM is operational, to direct work as it is being done. and it needs to be relevant, and the workers involved in the work need to be involved in its development. So the development of generic swims to hand out and say, hello, you're off to do a job, here's a pile of swims, is just got to stop. And I know that WorkSafe Victoria is highly critical of rolling up to site and seeing, 26-page swims. That is not a swim. A swim is, what are our high-risk construction tasks? What are the factors impacting on that task, making, increasing the hazard or creating the hazard? And how are we going to control them? And have we communicated that to all of our workers? And the party responsible for doing that is the employer, the independent contractor undertaking the actual work. The principal contractor on a construction site may well go, okay, I'm undertaking work that creates a risk of work at heights. So I'm going to create a swim for my site or for my work for work at heights. But each contractor, independent contractor, or the principal, whoever's doing the high risk work, needs to prepare the swim. The nature of a swim is that it must be prepared at the time the work is being done. Sorry, I'm just jumping around there a little bit. And the development of generic or prescriptive swims will not achieve the intention of the regulations. That's a really controversial point. I've just got a question. Does this information apply to all states and territories? Absolutely it does. And it is a very important point, and it's almost a whole other presentation in of itself. But the important thing is that swims are an operational document to assist us to manage risk. They are not required for anything and everything, and they shouldn't be being developed just, as a paper exercise. All right, so I'm going to jump back and go look at the 4 phases. So we've got pre-qualification, and I saw a question there that said, how do we demonstrate due diligence when engaging contractors and get them to confirm that they're undertaking their work safely? The court looked at this issue and basically said, when you engage an independent contractor, you are entitled to rely upon the reputation and representations of a contractor. So you need to make sure that you're employing people that you've got some confidence in, and we do have confidence from industry. People are members of the Master Builders Association, or they're members of, they've got their electrical license, or they're a member of their professional association or whatever. But really it's about making reasonable inquiries, asking the question, have you identified and controlled for the risks associated with your work so far as is reasonably practicable? I've seen pre-qualification question sets that are hundreds of questions long. The reality is you need to focus on outcome, not process. So I don't care if you have a training program. What I care about is that you confirm your staff are competent. So when you're designing a pre-qualification question set, think about what's the outcome you want to see, not the way that they get there. So demonstration of due diligence requires making reasonable inquiries to confirm that they have contractors have safety arrangements. This is probably the bit people struggle with the most, because they go, but how can I just rely on a yes/no answer from a contractor? Well, if your relationship with your contractor is so poor that you don't trust them to answer you truthfully, you shouldn't be working with them. But also, this is really about managing liability and establishing expectation. To say, I'm giving you a question set which shows you clearly what I'm expecting you to have in place. And if you answer yes, I will hold you to it in the event that something goes wrong, or I may well, through my monitoring, come and check on you at a later date. But this phase should be short, sweet, and focused. And it's unfortunately where most of our effort historically has been put, where people go, I want to see all your paperwork, I'm going to go through it, I'm going to check it, I'm going to come back to it, I'm going to make you change it. And we spend weeks, literally weeks, going back and forth, changing safety documentation for zero impact. So this bit should take 30 minutes. Ask the right questions, get the right contractual clauses, and get yourself set up and establish the roles and expectations between you and your contractors, and move on. The next phase is, I've just got that about swims again. The next phase is around onboarding. And really, from phase 2 through to phase 4 is where the operational side of safety management starts to happen with your contractors. And I think is the most important part of the prevention and the really, getting to grips with managing this contractors well. But onboarding, which is really induction, I again have looked at hundreds of inductions, and most inductions focus on, I'm going to tell a contractor how to do their job. So when you, as the electrician, come on site, I'm going to tell you that you need to use an Australian standard ladder. I'm going to tell you that you need to isolate live electrical works. I'm going to tell the trenching person that they have to dig a trench to a certain depth. They have to use batters, all that kind of stuff. We're looking in the wrong direction. When you're onboarding a contractor, you should be focused on telling them about your risks and how you can hurt them. So when you are coming to work for us, we are a chemical company, and you need to, as Mr. Contractor, need to understand where you can and can't go, if there's any PPE required on our site, what our emergency arrangements are, all of those things. So we really need to focus on ourselves, look at ourselves, because that's what we're liable for. And that's where we have the most control. So we need to focus on hazards posed by us to our contractors, our incident response, emergency management arrangements, and any minimum site safety rules. So you're quite entitled to say to a contractor, you're not allowed to weld in that area because there's flammable materials or whatever it might be. But you focus on your business, not on how the contractor's actually doing their job. I'm going to do a quick scan of the questions again.
I'll have a quick look at the question.
It's just got here, can you comment on when both parties have processes in place, for instance, confined space entry and lotto procedures? Yeah, it's an interesting one. I often see principal contractors issuing permits to independent contractors for things like confined space entry, hot works, all the rest of it. The reality is confined space entry permits is a risk management tool to manage a specific risk. Whoever is working in the confined space needs to manage that space. Now, as a principal contractor, you have an obligation to identify and put signage up to say this is a confined space. But in terms of entering that space, whoever's doing the entry should be managing it. Don't double up, because all it means is everyone goes, who's doing what? We're all confused now. And invariably, no one does anything. And what was the other one? Oh, and lotto. Now, lockout, tag out, fixed plant. My suggestion is that's probably the principal contractor's obligation, because it's their site. It's a site safety risk. They have to make sure that any plant that a contractor is working on is locked out. Baiada, interestingly enough, had a second incident, a horrendous incident, where a cleaner was cleaning inside their poultry factory and was working on the line where they had the chains that the chickens would come through on, and was decapitated. They tried to run the argument that the contractor was an independent contractor, therefore Baiada had no obligations. I can see everyone's going, oh my God, nodding their heads. Because of course Baiada had obligations. It's their site, it's their plant. They needed to make sure that that contractor was safe when interacting with that plant, and make sure that it was locked out so that contractor could be safe. So what you get good at when you start to think this through is who's got control of which element of tasks and activities. And really, I've been doing this for 10 years, and even though there may be overlap in time, it's not actually that common for people to have overlap in tasks. Generally, what I find is there is a real separation between I'm doing this and you're doing that. We're doing it at the same time, but we are responsible for different elements of a task or different tasks in the same space. And we have to manage them ourselves and be clear on who's actually going to manage it. Okay, I'm just going to jump back in here. So I'm just going to scroll down. Is this dependent on what is in your contract regarding which company's HSE plan you are working under? If a subcontractor agrees to work under a PC site HSC plan and permit to work system. If the contractor agrees to do that, they're under your system and you're totally liable. Okay, so yeah, for sure, you can say, no, independent contractor, I don't feel comfortable with you working to your own safety management systems. I'm bringing you in under mine. And that was like with Waco. Totally fine to do that, but there are obligations and consequences for doing that, which means you better have training, supervision, and all of that stuff to make sure your contractors really do comply with your safety management systems. There's a question here about federal safety accreditation. We've been told on numerous occasions we will be prosecuted if there was a fatality on our side, as the site is under our control, irrespective of how independent the contractor is. Similarly, we have not received non-conformances in relation to specialist independent contractors not meeting the WHS obligations, blah, blah, blah. Look, the Federal Safety Commission has been problematic for a long time. I know they've changed their stance around swims and they now accept that it is the obligation of the contractor or the party undertaking the high risk construction work that to develop and implement swims, monitor them and so forth. I have difficulty with sweeping statements like, you know, we would be prosecuted if there was a fatality on our site. You can't make a statement like that because the factual matrix around every situation is different. Do you find construction is a bit different beast when it comes to contractor management? No, it isn't. It actually isn't. When I first started in this field, I steered clear of construction because I thought it was some kind of weird, complicated thing. It isn't. It is entirely different to, entirely the same as all other contractor management in all other contexts. The principles are exactly the same. I'm going to respond to this question because I'm a little bit concerned. It says, as site OHS representatives for the company, we are obliged to write permits, swims, JSCs for contractors. One, you're an OHS rep, you're not obliged to write permits. Please don't be doing that. It's not part of your role. And two, yeah, problematic if you're writing swims for contractors and so forth, and I'd be really looking at that closely. Are you able to request swims and necessary documentation? Of course you are. Of course you are. And it's actually a nice segue into the next phase of the process, because once you've pre-qualified them, once you've onboarded them, given them all the necessary information, you say to yourself, right, well, I'm not kind of comfortable with just letting them go out there and do their own thing. If I was a school, I probably would just let them go and do their own thing because I've got no idea what I'm looking at. But as a large construction company, you say, no, look, I'm actually going to take some oversight here. But monitoring should be restricted to what you are competent to monitor. So often I see people trying to monitor an independent contractor, getting out, asking lots of questions about why are you doing this and what's happening with there and do you think that's okay, when they have no idea what they're looking at. And I include myself in that. You know, we need to say, can I actually competently monitor this? If you're not competent, then don't. Even if you are monitoring, don't assume responsibility for ensuring implementation of a contractor's safety arrangements. Ask questions, ask the contractor to clarify, always refer matters back to them for them to respond to. Raise safety concerns. That may include saying, hey, I feel really uncomfortable. I think you better stop work and tell me why you think that's okay and explain to me why you think, you know, you've got your risk management under control. If you're still not happy, say, look, I'm still not happy. I think I'd really like you to get some expert assistance from a suitably qualified safety professional who's certified by the Australian Institute of Health and Safety. Don't prescribe corrective actions. Again, if you do, and you may, because you might say, actually, I am going to prescribe, just make sure you take it all on board and say, right, I've just prescribed an action and I'm going to make sure that this is really implemented. Again, monitoring should be undertaken while work is being done, or at least as close to when the work is being done to actually, for the contractor to actually understand what work they're doing so that the risk controls are relevant. And generally, principal contractors do not audit contractor safety management systems. If you want an audit done, get the contractor to get an external auditor to come in and do it. because then you have an independent party who's doing the audit, can hand over the report, and it's all good, and you're just not caught up in that whole process. So monitoring is really about, one, you've asked them to pre-qualify and confirm that they've got certain things in place. So if you want to go out and say, right, in the pre-qualification, you said to us that you had processes in place, or you have licensed staff. I see you've got an electrician there. Can I see his license? Monitoring and providing, asking for evidence of what it was they pre-qualified. That is when it is most meaningful. If you've asked for a list of licenses at the pre-qualification phase, you can bet your bottom dollar that by the time you get out on site and the job is actually underway, half of the people whose licenses you have are not even working for the contractor anymore. So monitoring your pre-qualification, monitoring compliance with your safety instructions and induction. So if you have issued an instruction around you are not allowed to go into this area, you have to comply with our traffic management, you have to not undertake hot work in this area, make sure those things are being complied with, because again, they're your site safety rules. All right. So again, switch your monitoring around to looking at yourself and looking at what your contractors are doing to work within your safety management systems. So here's a question here about engaging subcontractors. I just got here, with regard to an example where the site owner employer has an on-site main contractor, but from time to time the main contractor needs to engage a subby. Any thoughts or comments on the site employer still holds the main contractor responsibility? Yeah, if this question is in relationship to appointment of a principal contractor, so the site owner has appointed a principal contractor, that principal contractor has gone out and engaged a subcontractor. The owner of the site, by making that appointment, has handed over all of their OH&S obligations. Okay, so the principal contractor is the one that is responsible for the relationship with the subby. All right, so need to be really clear about that. People say you cannot delegate or contract out of your obligations. Under the regulations in the construction regulations, under the appointment clauses, you actually can, because you're saying I am giving this principal contractor role to this third party, and therefore I'm handing over all of those obligations as a principal. Okay, so so we've got our phase 3 monitoring, and as I said, think about where you're actually focusing your monitoring efforts. And then the last element is phase 4. So if you really want to demonstrate due diligence and close the loop, you need to be going back and saying, well, okay, what did I find? I had the effort of pre-qualifying. I took the effort of onboarding them and inducting them. I did some monitoring. What does this mean going forward? And the performance review will be the thing that tells you, well, should I use this person in the future or not? And it may, and you know, it's evident then that you have actually closed the loop, gone back and said, well, they told me in pre-qualification that yes, they undertake high-risk construction work, and yes, they prepare swims, but when I went on site and there was work at heights being undertaken, they weren't able to produce a swim. So take the outcomes of your monitoring exercises. So things like, I mean, good old incidents, but, you know, results of monitoring. What was it like when I went on site? Did they have evidence of their pre-qual? Were they complying with site safety rules? Also look at things like, look at reports from your own employees, other people working around the contract. Look at, did they remediate issues when you raised them? Were they cooperative with you in coming to conclusions and solutions? And use that information to actually go back and say, well, am I actually going to use this contractor again? And that way then you're weeding out the ones that you're not happy with, and you're protecting yourself under those due diligence requirements by using contractors that you know have a good reputation and actually do undertake their work well. So
You, Sue, it's almost
yes,
5 to 4.
yes, I saw that. So look, I'm just going to quickly go through a couple of, as opposed to principal contractors to subcontractor, have you come across excessive workplace health and safety oversight of principals or clients to principal contractors they employ? It's an interesting one, actually, and I'm doing some work with a very large employer at the moment where they are actually moving to a significant appointment model where they are appointing a lot of principal contractors. And I've actually had to say to them, you need to pull back from how much oversight you're putting on your principal contractor, because the reason why you're appointing them is because you've satisfied yourself that they're capable of doing the job, that they are competent to be a principal contractor. And by constantly coming in over the top of them, you're running the risk of reinserting yourself back into that relationship. And the thing that I do see is, we've got the owner of the job, we've got the principal contractor who's been appointed, and the owner of the job comes back in and starts telling the principal how to do their job. And all that you've done is undermine that authorisation and that appointment. So that's a good question. From a different perspective, does a permit system fulfil the principal contractor's part in managing their risks and potential interaction with subcontractors? Look, as I mentioned, permits are just a risk management tool, and they should be in relation to specific hazards. And I think they're actually overused. We have permit systems for, I don't know, all sorts of different things, hot works and so forth. I mean, they are a tool by which you can say, have we got certain risk management processes in place to control this risk? Tick, yes, you're good to go. And then at the end of it, I can close the permit out to say, yep, all's good, the job is finished or whatever. So permits need to be, I think, put under the microscope a little bit more than they will. I've got this other one. On occasion, when we are acting as a principal, the client will not let us proceed until they approve safety management plans and SWIMs. We are forced to change them, dear. From a legal liability view, would the client be forced to accept some liability in the event of an issue occurring in relation? Absolutely. And they need to do one of my webinars, because they are really putting themselves in the gun and going, okay, I know more than you. I'm going to tell you how to do the job. And the court will say, great, you knew more than them. You told them how to do the job. It's all your liability now. Debate regarding whether a JSA meets the legislative requirement of a safe work method statement. It's an interesting question, because the reality is, the way I see it, is a job safety analysis is a process where you look at it and you go, what's the job, what are the hazards and what are the risks? The safe work method statement is the written document that supports that process. So really, they're kind of one in the same process. And I actually, for the clients I work with, I just say, look, we need to be clear about our language. So you prepare SWIMs, you do JSA. Should the principal contractor not review the SWIMs? No, they shouldn't, because again, you've got an independent contractor, that's what they do, that's their expert work. Are you competent to do it? In the first instance, doesn't mean you can't work cooperatively with your contractors, to come up with solutions and so forth, but primarily, keep these things separate. What's the difference between a principal contractor and a PCBU? A principal contractor is a PCBU. A PCBU is a a person conducting a business or undertaking. So it's just / employer. So just watch your terminology, just to be clear about, are you aware if the Australian perspective is the same in New Zealand? Yes, it is. The Supreme Court, High Court in New Zealand handed down a decision in 2013 that reflected exactly the same High Court decision here in Australia. So can a SWIM include an SOP as a control? A safe operating procedure is generally, I think, a description on how you use a piece of equipment safely. And yes, a SWIM might say one of the risk controls we are adopting within our safe work method statement is using a piece of equipment, and this is how you use it safely. All right, so we are at 3:59 and there are 58 questions. And I'm not going to get to them all. But look, I hope that people the reality is these webinars throw out probably as many questions as they answer. I'd really like people to jump on LinkedIn, join me on LinkedIn, email me with questions, you know, call me or whatever with more clarification, because a lot of this stuff, surprisingly, 10 years after I started doing it, is still fairly new. So you're not alone if you're sitting there going, oh my God, this is so different to what I thought. But, you know, it's a very important topic, and it's important that we focus our efforts in the right direction in terms of managing our contractors to get the best bang for our buck in terms of improving safety management on when we're working with our independent contractors. Sarah, are you there? Yes. So we're 4 o'clock, so we need to finish up. Is that right?
Yes.
Yes. All right. Do you want to finish up?
I was going to say, just to let everybody know, there has been a few questions come through. This webinar today was recorded. So in about 5 to 7 business days, we'll send everybody who registered a link to view the recording, and also with the slides. Yep.
Yeah. And look, there's some really nice, just quickly, some comments coming in about, you know, agreeing that it's the workers who should be developing swims. These are operational tools. They should not be being developed by safety professionals sitting in the office. You know, I've done it myself. Don't worry, I've been a safety professional for 20 years. I've done it all. But you know, safety is operational in nature. It's about what is going on site and what should we be doing to control these risks. And it's got to start from the ground up in terms of our operational response to risk. So yes, thank you for your time. I hope it was worthwhile. I was probably a little bit rushed. It's a lot to cover, but I might even talk to the AIHS about doing a couple more webinars and picking out some of the more specific details of this topic and running some webinars where we hone in on some of this stuff a little bit more, in a bit more detail. Thanks, Sarah.
Thanks, Sue.
Okay.
Bye.
Bye.